5 seconds from now. By virtue of the impugned amendments, very Constitution is amended by inserting new clauses in Articles 15 and 16 thereof, which empower the state to make reservations by way of affirmative action to the extent of 10% to economically weaker sections. It is the case of the petitioners that the very amendments run contrary to the constitutional scheme, and no segment of available seats posts can be reserved only on the basis of economic criterion. As such, we are of the view that such questions do constitute substantial questions of law to be considered by a bench of 5 judges. Further, on the plea of ceiling of 50% for affirmative action, it is the case of the Respondent Union of India that though ordinarily 50% is the rule, but same will not prevent to amend the Constitution itself in view of the existing special circumstances to uplift the members of the society belonging to economically weaker sections. Even such questions also constitute as substantial questions of law to be examined by a bench of 5 judges. The learned counsel has, while extensively relying on the Constituent Assembly debates preamble and Article 38 of the Constitution, which enjoins the state to secure and protect a social order in which justice, social, economic, and political shall inform the institutions of the normal life, stressed that it was to ensure this social justice and the ethos of the Constitution that special provisions were envisioned under Article 15(4) and reservations in employment were provided under Article 16(4). He argued that it was due to certain primordial practices that a section of population was marginalized and was deprived of material resources and educational opportunities. The people in the lowest strand of social hierarchy were ostracized and stigmatized from public life and were deprived of basic liberties and equality. It was to address these historical inequalities that, as a vehicle of positive discrimination, the socially oppressed sections were provided reservation and special provisions so as to give them a voice in administration, access to resources such as education and public employment. Therefore, the idea of ensuring social equality and justice was a congenital feature of the Constitution shaping its basic structure. The learned counsel has argued that this basic structure has been violated by the amendment in question, which seeks to empower the privileged sections of society who are neither socially and educationally backward nor inadequately represented. He also submitted that the amendment in question has introduced those sections of people as economically weaker who were never subjected to any discrimination, whether historically or otherwise, and were not backward socially and educationally. The learned counsel has further submitted that the non-obstinate clause in Articles 15(6) and 16(6), while granting reservation to already privileged and adequately represented class of citizens, has vetoed the prerequisite of being socially and educationally backward or inadequately represented, which was the kernel to philosophy of reservation. The Constitution puts forth social and educational backwardness and not social or educational backwardness as a criterion to determine positive discrimination in favor of a class. Stop. Hello aspirants, please subscribe to my channel to get all the dictations of the latest judgments of High Courts and Supreme Court. Thank you.